Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Anora Wang. Today's topic is Mother May I, the use of prior approval requirements in merger settlements. Joining me today is my co-host, Jeny Maier. Hi, Jeny.
Hey, Anora. How are you?
Would you please introduce our guest today?
Absolutely. Today we have with us Bilal Sayyed, who is a counsel at the law firm of Cadwalader, Wickersham and Taft, where his practice focuses on merger review, antitrust litigation, and counseling on complex competition issues. Before he joined Cadwalader, Bilal served in various senior leadership roles at the FTC, including as the director of the Office of Policy Planning from 2018 until 2021. And he also served as an attorney advisor to then FTC chairman Tim Muris from 2001 to 2004. So these experiences really have provided him with extensive experience dealing with merger enforcement, as well as remedies from the agency's perspective. So we're really looking forward to hearing from him today. In addition to his work at the FTC, Bilal has also taught antitrust and competition at George Mason University since 2011. So thank you very much. We look forward to talking to you today.
All right, thank you. I'm happy to be here, and what better topic to talk about?
It's always great to have a former law school professor to myself to come to the program. Welcome, Bilal, and it's a pleasure not to have to address with professor titles. I feel like we're already on a more equal footing now, which is great. Can you kick the show by explaining to our audience what prior approval means in the context of merger consent orders?
Okay, so I think I can do that. Most of us are familiar with the Hart-Scott-Rodino Act prior notification and waiting period requirements for transactions that meet the jurisdictional thresholds. Prior approval provisions go further in maybe two ways. First, of course, they may capture any acquisition that a party who's subject to a prior approval requirement may make. And of course, what it means is that to consummate the acquisition, the parties must, in fact, get the approval of the Department of Justice, or more likely, the Federal Trade Commission. Right. So it is not. It kind of shifts the burden. Right. The parties have to get affirmative approval rather than sort of what you might call a negative clearance or no action from the FTC or DOJ.
And under what circumstances you might see the agency actually seeking such a prior approval provision in a consent decree?
So I think there are a couple of situations, and maybe the overarching situation you'd see it is something like in the Biden administration, where you may want to put a damper on future acquisition activity by all parties or any party to a transaction, particularly that transaction that raises substantive issues. But more generally, the prior approval provisions, just like prior notice provisions, but with the distinction of notice versus approval, arise in a few instances. One, when there's a concern that future acquisitions may not be subject to the HSR Act reporting requirements. And you want to make sure not only that you get notice of them, but that you can, in a sense, delay parties from consummating those acquisitions, in a sense, subject to your own timeline as an agency. You may see them when you have concerns about the buyer of divested assets in a particular transaction. That buyer may be placed, may have a prior approval provision placed on them for the sale of the assets that they've acquired in a divestiture transaction. Just go back a second. Almost all orders now, whether they're consent orders from the FTC or final judgments from the DOJ, include a prior approval provision with respect to a purchase or repurchase of the divested assets by the company, by the surviving company under order. You may see them, you will see them in the administrative litigation filings, the FTC files, in its Part 3 process. In the back of that administrative complaint, there is a sort of a request for relief, and almost now uniformly, you're still seeing the FTC ask, or at least put the parties on notice that they may ask for a prior approval provision if they're successful in their challenge, right? And then I think I've seen this, but I couldn't find it prior to our discussion. I think in some instances, the commission may try to place a prior approval provision on the seller of assets in a crater deal where there's a concern that the seller may try to shop those assets to a buyer that where the transaction would not trigger a Hart-Scott filing, right? And of course, you might ask, why does in this case, the commission have the jurisdiction to impose a consent order on the selling party? And part of that is because often the FTC will challenge transactions under both Section 7 and Section 5, where the Section 5 violation is not the consummation of the acquisition or the potential consummation of the acquisition, but the agreement to sell or merge, right? That agreement itself is allegedly a violation of Section 5, and both parties are parties to the agreement. Whereas the Section 7 violation really goes to the acquiring person, right? So that's a way you can put a prior approval provision on the seller in a crater deal if you think they may, shop the assets in a way that raises competitive concerns in the future without a Hart-Scott filing.
It's really interesting, and maybe would help to take a little bit of a step back and for kind of any of these prior approval provisions, either in a restricting the acquiring company from subsequent acquisitions or restricting a divestiture buyer from selling the acquired assets. What are the purposes from the agency's perspective of including these kinds of provisions? What are the competitive issues that they're trying to solve?
So I think there are two issues, or maybe more than one issue. First, I think they want to avoid, as best they can, reinvestigating and relitigating the same or similar deals, which they feel might just be, I'll call it, somewhat obnoxious by the parties, right? To try again on a deal that's been challenged, but maybe sort of repackaged. I think it's intended to prevent maybe one or a series of small acquisitions in the same relevant market or sometimes slightly broader market, both by product and geography. So prevent a series of small acquisitions that would not be captured by the HSR Act. Of course, they don't want parties to basically be able to unwind the divestiture by buying the assets after divesting them in accordance with a judgment or order. And of course, the core question is, they can do that with a prior notice provision as well, right? Because I think we're all familiar with the fact that most of the prior notice provisions basically say you have to give us prior notice, or if transaction is not reportable, and will probably follow more or less the processes available to parties who file under the HSR Act. prior approval provisions don't generally give parties that kind of protection of a process. And I think that's why many of us think prior approval provisions are not only intended to stop or give the agency notice of potentially anti-competitive transactions, but to discourage parties from consummating either future acquisitions or even the acquisition that might result in the prior approval condition in an orders, right? So basically, this is an effort to use, to put a clog on merger activity and not just identify anti-competitive transactions that may not be otherwise reportable.
Thanks for that distinction. I think prior notice is that you give the notice, but you have to wait for approval, right? And for prior approval, you have to affirmatively actually getting approval, right? That's sort of like a more lengthy process and more difficult.
Yeah, I think that's right. I mean, the prior notice provision usually includes language that says something like, "We'll follow the HSR process." So, it gives the government a period of time in which they have to make a decision, and at some point you can kind of trigger a clock on them or a requirement that they make a decision. Prior approvals are different in a number of ways. One is, as you said, the government has to make an affirmative sort of grant of okay, but the process includes no actual process to get them to do that, right? I mean, you think about either the Hart-Scott filing and maybe even the prior notification process. People tend to use the Hart-Scott form, and there's some agreement on following the HSR process. Prior approvals, there is no form, right? Parties often file the equivalent of a white paper. As the process, you probably go in and say, "Look, we're thinking of selling or buying. We'd like to talk to you." You enter into sort of discussions, and you possibly come up with a sort of a list of information that the staff would like to see as part of your application. You file something like a white paper. You don't have protections of the HSR process or some agreed on process of how long it will take. So I think, the general sense is prior approvals take a lot longer to get done if you go that way.
Yeah. I do want to address the other side, I guess, the flip of the coin. So not the other side of things, I guess. It has been argued that prior approval requirements, since it is lengthy, more difficult, it would have a little bit more teeth in it, right? So as a tool for the enforcers. So it would be better able to prevent serial acquisitions in perhaps an already concentrated market, and it would reduce the burden on the enforcer by what we're describing, right? Like the lengthy and the difficulty by deterring problematic follow-on transactions before they occur. What are your reactions to those arguments?
Well, I think it's correct that part of the reason for prior approval is to discourage transactions that, the parties or the agency may feel are unlikely to be cleared, but which the parties might otherwise say, well, let's take a shot at and see what the commission does, right? Because it's a prior approval process, the commission or the staff can just, in a sense, refuse to do anything, right? Whereas under either an HSR filing or a prior notice provision, at some point you can sort of push the staff or the commission, and there's a reason we're talking mostly about the commission. You can push them to make a decision, right? So I think the only rationale for a prior approval position is to shift the burden, the ultimate burden, sort of on the merits of the transaction, from the government to the parties. It is a fair point. It is a fair point that the commission, the staff, or either agency has relatively scarce resources, and so they ought not to be asked to do things repeatedly. That will be problematic. But the identification of anti-competitive transactions that are below the Hart-Scott filing threshold can be identified using the prior notice provision just as easily as the prior approval provision. From my perspective, sometimes at the agency, you do like to see deadlines. If you're in management, you do like to see deadlines because they might force decisions and the freeing up of resources or the best use of those resources. And I think maybe this is just me, maybe this is my dirty little secret. If I don't have a deadline, sometimes things just don't get done, right? And I think that's also true in the government. But that creates its own sort of wasting of resources and diversion of effort.
Interesting. It, clearly is a choice on behalf of the government to make the policy choice between whether they will ask for prior notice versus prior approval. What recent policy changes have taken place with the FTC in particular in its sort of approach to using these provisions?
Yeah, so and let me make one other point just to come back to it. I mean, it seems like it's perfectly reasonable to not allow the parties to rebuy the divested assets and really just, make it a prior approval requirement, right? Because coming back seems like a huge waste of time, and you don't want to put that burden on the government. Okay, so what's happened recently? Look, go back and look at a little history. Back in 1995. The commission moved away from its advanced the policy statement that moved the commission away from sort of the routine use of prior approval and prior notice provisions in merger settlements. The DOJ had not historically, at least to my recollection and review, DOJ had not generally used prior notice and prior approval provisions in its orders. And so the FTC's adoption of that policy sort of aligned them with DOJ in not routinely requiring prior approval and prior notice provisions. Let's say the first year of the Biden administration, June, July of 2021, the commission rescinded that policy, and a few months later, in October of 2021, adopted a new policy, which was in fact the reverse of the old policy, that they would go back to what they believed was the historical practice of routinely requiring prior approval provisions in merger settlements or consent orders. As a general matter, those prior approval provisions were focused on and maybe even limited to acquisitions occurring in either the same product market and or geographic market, right? But sometimes they were broader to include other products or broader geographic regions. And after the adoption of that policy in 2021, the commission, in the consent orders that the commission accepted during the remainder of the Biden administration, there was, I'd say, routine use of prior approval provisions in transactions that were settled by, divestiture relief, right? I don't think you saw them included, and I think you'd be unlikely to see them included in merger settlements that were conduct-based, sort of like the settlements in the Chevron and Exxon matters, where they were sort of focused on the position of a particular person and at least the allegation that coordination would increase through that person's participation on the board of the combined company. But you saw it routinely in the FTC consent orders. Of course, the Department of Justice in the Biden administration rarely entered into final judgments or settlements, preferring, or at least arguably, sort of fix it first approach to resolving concerns. And so, notwithstanding this change in policy at the FTC, reversion to the historical policy, you didn't see you didn't really see any change at DOJ because they just, were not entering into settlements.
What about the other federal agency? Has the DOJ's approach differed from the FTC's with respect to prior approvals and settlements? Talking both historically and in the current policy environment.
Yeah, historically, yes. DOJ, I think, has, well, I'd say when I got to the commission in 2001 with Tim Muris, there was some general thought that the Department of Justice rarely paid attention to its success or even monitoring of the settlements, final judgments that they entered into, which was in some ways borne out by the fact that they did use a lot of fix-it-first settlements where there was no order and or decree and no Tuniac process. So that continued, and that continued throughout the first 2 decades of the 21st century. You did not see prior approval provisions in DOJ settlements outside of some of the things we talked about, which is acquisition of the divested assets. And it continues, I think, today, not in all cases, but in most cases, DOJ is not requiring, prior approval outside of the reacquisition of the assets. The FTC in this administration has largely moved away from prior approval provisions, again, with the limitation of acquiring the divested assets. But they do continue to place at least a request or notice of it in the administrative complaints they file. I think, though, DOJ, for example, in the Ready ICE transaction that they just settled, there is a limitation on the reacquisition of divested assets. There is also a prior approval requirement for taking what I'd call an ownership interest in the firms acquiring the divested assets, right? So sort of an indirect reacquisition of those assets or an interest in those assets. There's also a restriction on entering into what you might call non-ownership relationships with the acquirer of the divested assets. And so I think, what you see is DOJ and the FTC, but I think you see it more just maybe because of the cases. I think you see DOJ thinking about relief that is tailored to the transaction and the settlement, right? And of course, I think that's sort of what you want to see, right? Not a blanket policy one way or the other, but relief that is tailored to the concern or the transaction or the divestiture.
You mentioned earlier that oftentimes or at times prior approval requirements can act as a clog on M&A activity generally. Do you see the sort of changes over the course of the change in administration from Biden to Trump as being a way that the agency is communicating a more deal-friendly environment?
Yes, absolutely. I think both agencies, clear, they are willing to accept settlements, right, as opposed to litigate or push for abandonment of transactions. I think you also see the division, at least under Gale, where the division wants to be transparent about their settlements, and in fact, may be concerned about sort of the monitoring of compliance with settlements as opposed to sort of fix-it-first transactions. So I think parties have seen that the government is trying to get out of the way of otherwise, both fixable and beneficial transactions. I mean, I think we probably all had the experience in the Biden administration where we had a client who might have been able to obtain a settlement from the FTC of a particular transaction, but the FTC wanted a particularly broad prior approval provision, which would impose significant burdens on the parties going forward that made the current deal, the deal they were sort of focused on, just too prohibitively expensive in a sense to settle. So I think clearly the Trump administration, second Trump administration, has signaled it is not trying to overburden parties to deals, but I think trying to tailor their requests to, get transparent relief that they can monitor and confirm compliance. And the place where you see request for prior approvals, in the broad sense, is on the administrative litigation, where I think the commission has sort of made a decision that we want to block this deal and we want to cause some pain to the parties, right? And one way to do that is say if we do go to administrative litigation, we're going to seek a prior approval provision rather than a prior notice provision. So I think they're using it more in a more tailored way and a way that parties can sort of work with, right?
I think you've already mentioned the practical implications for a company subject to such a prior approval requirement. It's just more burdensome, and it perhaps would even deter them from doing more deals. Now, in light of the changes or indications of changes they just talked about, at least at the FTC, should parties subject to a prior approval condition that they already have, right, consider seeking some sort of like a modification or rescission, like try to do away with these provisions, and under what circumstances?
So I do think parties who are under a prior approval restriction, in the broad sense, right, not limited to the repurchase of divested assets or something similar. I think they should seek a modification from prior approval to prior notice, or even sort of a rescission of prior approval to sort of basically put the commission on just reliance on the HSR Act. Now it is unclear how the commission will react to that, right? Or there is some value in sort of matters being settled and not reopening them in short order. But I think parties that do seek modification or rescission, should understand that there is a framework for that, right? Basically, a change in the law or change in fact, right? And if they can show a change in fact, then they ought to pursue it, because that is that there is no reason to maintain that burden if factually the burden in a sense doesn't get you anything. But it's really, there really hasn't been a change in law, right? There may have been a change in the policy, but and so the commission might take the view that they ought to align recent decisions with current policy. But of course, the commission may take the position it's a waste of resources to redo something. It may take the position that you could seek to modify at the time you actually would otherwise have to request approval. So while I think parties should try it, it's not so clear that they're going to get it just because of arguably change in policy by the commission. There, just to give you two instances of modified antitrust matters in the past, the Toys R Us order was modified I'll say 10, 15 years after it was put in place. And that was because Toys R Us was no longer, dominant or had any real market power in their relevant market, right? Changing facts. And so it didn't make a lot of sense to keep Toys R Us under that order. Another case was change in law. There was a small number of companies under orders that prohibited them from engaging in resale price maintenance. And after the Legion decision, they moved to modify or rescind the restrictions related to engaging in RPM because of the change in law with respect to RPM. And the commission, I think, uniformly granted those modifications.
Gazing into a crystal ball perspective, as we've talked about today, there's a sort of policy perspective that the sort of administration under Biden and Chair Khan had versus the policy perspective that the current administration has under Trump with respect to using prior approval. Where do you see this going in the future? Do you think that the policy will continue to ping pong depending on who's in the White House at any given time, or do you foresee there being a consensus again?
So I think what I foresee is for it to ping pong back and forth between tougher and looser standards, which I think is a mistake. I think the better approach is sort of, what is it that Breyer said, I think it was Breyer in CDA, an inquiry met for the case, right? I mean, I think, the staff at both agencies and the leadership at both agencies should think harder about, when a prior notice and prior approval provision is needed, which is the better tool, where that, which burden, you should impose on the parties. And under what situations. So to me, it should be sort of case by case, right? As I said, the ready ICE has a little bit broader prior approval type position than you see in the other DOJ consents, which are solely focused on the divested assets. Repurchase of the divested assets. I don't think the commission should use it as a litigation stick, right? I don't think they should be uniformly asking for prior approval in their administrative complaint, notice of requested relief. I think it would be better if, the agencies continued on what I would call, step-by-step improvements over time, right? To bring more sense and more coherence to either their individual matters or across the division or the department and the FTC, right? I mentioned when I first got to the commission with Maier in 2001, the view of the compliance staff was DOJ did not pay attention to their, compliance with their orders, and that was a reason they were willing. Well, and I think that was a reason they were willing to accept, fix it first on a substantial, percentage of their settlements. I think there was some view of that too. Even when I got back to the commission the second time, that DOJ was less attentive. I think Macon brought some more seriousness and coherence to the what I'll call the remedy or compliance process. I think they had to look at, and this is not a structural acquisition type thing, but they were forced to look at Ticketmaster, Live Nation, and I think Macon said, "Why the hell are we, not being tougher on compliance type measures?" So I think it will ping pong back and forth, but the better approach would be slow, steady, thoughtful policy development.
Thank you. This has been a great conversation. We've learned a lot. I certainly have. We try to sort of wrap this program usually with a little bit of like a personal segment where people can learn a little bit about you, not just how you think as a practitioner or academian, but also to know you a little bit better as a person. So just to share perhaps one thing, about yourself that people would not know about you if they had only dealt with you professionally or have only heard from you from classes or sit with you across the business table? What would that one personal thing would be?
So, God, I think, of course, the first thing that comes to mind is I am as boring as I am personally, as I am professionally. But, maybe that's not true. I think, not only, I think my friends know I like to travel. I don't know if my professional colleagues know that. And I think, maybe even sort of related to that, I have, this is almost embarrassing to say, but I guess that's the point of this. I think I have about 100 cookbooks, and I never cook. But the reason I continue to buy them is I find, the stories around the the cuisine or the specific dishes are kind of interesting and a little bit of a travel type discussion. So I read a lot of cookbooks, but I don't actually cook from them. And the best cookbooks are, to me, the ones that are sort of a combination of a travel and sort of recipe cookbook combination. So I don't know. Maybe that's a fun fact. I don't know.
That's inspirational, at least, or at least you remind me of someone who wants to learn how to swim, but just by watching YouTube videos.
Well, I don't actually want to learn how to cook, right? I have no interest in cooking, right? It's a lot of work. I'm making a lot of mistakes. If I want, food like I see in the cookbooks, right? I go out and, buy it, right, at a restaurant. But the stories are great, right? And sometimes it'd be nice to sit with the chef and hear their stories, right, of why this dish, why that dish, how they came up with the combinations. But no, that you don't usually get that option. But I can read in the cookbooks, right? And I don't even know if those stories are true, right? But whatever, they're kind of easy to read,
Yep. Yep. Fascinating. At least makes you a good food critic. Yeah. Now we turn to another silly segment called Curious Hat.
And now it's time for the Curious Hat.
One reason we do this is the big voice. That's just kind of sometimes startles people, and I like that. So the rule of the game is very simple. You give me a number between 1 and 20, and I give you a corresponding question.
All right. Well, today is the 17th, so I will say 17. Oh, I'm supposed to not date this. Okay. Well, February 7th. February 17th.
That's fine. It could be 17 of any mysterious month that we're recording. Yeah. 17. If you were given $50,000 US on the condition that you had to spend it all in 1 hour, what would you buy, or how would you spend it?
Well, that's a good question. I have a collection or copy of Hovenkamp's treatise, so I don't need to spend $50,000 on that. It's not $50,000, but that might otherwise have been how I use it. How would I use it? I would probably use it to buy a lot of airline tickets to go in multiple places.
And get more cookbooks.
Get the actual stories from the people, in the living on the rivers or the seas or in the wherever. Yeah. So I would, if someone gives me discretionary income that I have to spend, I would spend it on travel. And so I guess maybe I could take $50,000 and buy, a bunch of airline miles.
Fascinating. Thank you so much for sharing your insights on the substance and also on travels and cookbooks. I'm sure our viewers and listeners have enjoyed that. And thank you, Jeny, for being a wonderful host again and audience. Until next time.
Thank you. See you next time.
Thank you.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.